Hi, everyone. Welcome back to Active Self-Protection Extra and John's Briefs here again at C2. Thank you to them
guys.
for letting us use the conference room with Attorney Extraordinaire Tim Forshee, and here at the behest, and I'm super grateful to Firearms Legal Protection for sponsoring these videos because they're like, hey, we don't need you to shill our stuff, but we want you to talk about the good stuff that you talk about, and I appreciate them for that. And today, another round, another chorus of talking about jury nullification and what it means, because I see some people in the Second Amendment community talking about it in ways, frankly, that concern me, and in ways that I think are not as helpful. And so let's talk about what it is, what it can do, and what it can't.
To win the fight after the fight, you need help. After a use of force, I trust Firearms Legal Protection to help me win the fight for the rest of my life. From their 24/7 attorney-answered hotline to coverage for the use of all legal tools, Firearms Legal Protection has you covered. Get a discount by signing up at the link below.
So what I see this talked about, Tim, is I see it talked about in the Second Amendment community as, you know, these prosecutors that are, you know, dang liberals that are jamming up good people when they shouldn't. And so, you know, if I was on that jury, I would just vote to acquit no matter what, because he used a gun and that means he was justified in what he did.
Yeah. Sorry. I hope you don't have that mindset if you're going to be a juror.
Yeah. Please, I would encourage you, be honest on jury questionnaires, because you will
disqualify yourself.
You just get disqualified in a big fat hurry, because my experience is juries usually get it right.
Yeah, I was a judge pro tem for about 14 years, and I presided over, I don't know, I don't want to exaggerate, I would say probably 30 jury trials, something like that, where I was actually the judge, where I had to actually, you know, sort of run voir dire and make sure the jury instructions were appropriate, and all, you know, where I'm actually a lot of interaction with juries.
Being the referee.
Yeah, being the referee, if you will. Yeah, and I think juries, it's a much more complicated animal than people think they are, big time. And of course, you know, there's times when you give anything to play on a microphone in the jury box just so you, I mean, the trial's over, so you can't influence the case, but you just want to hear what they think and what they're saying. And it would help you be a better lawyer the next time. And you can always debrief a jury afterwards, but probably 80% of them just want to get home with their kids. So you only get the ones that want to talk, and those probably aren't the ones you want to hear from anyway most of the time. So that's been my experience. But yeah, the thing about jury selection is that if you want to get off a jury, it's very easy. You just have to say something that's horribly inflammatory. Sometimes that's honest, sometimes it's not, because people don't want to be on juries. But I always tell people that there's really only two things in our society that reflect on us actually being citizens, and that's voting and doing jury duty. Yeah. There's very few things, unless you're in the service, and God bless those of you who are or were. You know, really, those are kind of the only three things that you actually actively participate as a U.S. citizen. And when people blow off jury duty and ignores jury summonses and stuff, I don't think that's funny or cool. I think that's just you not doing your duty. I really do. So anyway. So getting back to that duty, if your duty in your mind is to go in and disrupt the process, you ain't doing it the right way. I mean, if you want to disrupt the process, do that at the voting booth, and let's try to get other people in there that you agree with. And I agree, we've got some real serious prosecutorial problems going on in this country right now. I find that rather than prosecuting the good guys and messing them up, what I find more commonly is they're not prosecuting the bad guys and messing them up. And of course, you can't deal with that as a juror. But yeah, you can't just go in and decide the case before you listen to the facts or ignore the facts and then just vote a certain categorical way because of your political beliefs. That's insane.
Well, and quite frankly, I mean, we see these kind of high-profile cases. You know, you see Kyle Rittenhouse getting prosecuted, which, I mean, again, Thomas Binger should be disbarred and probably do prison term for prosecuting that
tarring
case.
and feathering might not.
Might not have been inappropriate. You saw the George Zimmerman trial, you know, so you see these very high profile cases. Those are very rare, and they make national attention because of how rare they are, right?
And both of those, let's be honest, were completely politically motivated.
They were.
Absolutely.
No question about that. So when we talk about jury nullification, though, we talk about the jury standing in judgment not only over the defendant, but over the law.
And that's what's not allowed. So one of the first things you learn in law school is that the court is called the trier of law. And the jury, or if it is tried to the court, then it's difficult for judges. I've had to do it before, if it's a bench trial. But the jury is called the trier of fact, right? And nary the twain shall meet. So the judge decides the law and presents the law in the form of jury instructions to the jury at the conclusion of the case. The jury decides on the fact. Well, this guy said black, this guy said white. So is it black or white, or is it gray? And gray ends up usually with a hung jury, which is a mistrial. If it's black or white, you're going to get an acquittal or conviction. You know, you can believe that the state proved its case. You can believe that the person's technically guilty, but not believe that the law is an appropriate law, right? And we saw this a lot during Prohibition. You know, people that said, this is ridiculous that it's illegal to drink beer. And this guy got arrested for beer. And the jury decides, you know what? It's a corrupt law and we're going to acquit him anyway. They proved he had beer. And yes, beer is illegal, but beer shouldn't be illegal. We're going to acquit this guy. That's jury nullification.
And even more, I think before that, we saw this in fugitive slave laws.
Absolutely,
right? So
yeah, in the 1850s through 70s.
Yeah, 1850s when you had these really strong fugitive slave laws, felony offenses for, you know, a runaway slave for giving him food and water, or a place to hide out, and like felony level, decade in prison, you know, kind of things. And juries would just say no.
And that's a better example, frankly, and thanks for that. I forgot that because, you know, I think hopefully this day and age, everybody would agree that that was the moral thing to not uphold that law. So, you know, jury nullification sometimes is a very gallant thing. It's a very just, appropriate, gallant, moral thing.
That said,
it's weird. We've got a Supreme Court case, SPRAC, I believe it is, Sparf, there you go. It's one of those weird names from the late 19th century, where the court basically said they acknowledge that there is a boogeyman, that jury nullification exists, but you're not allowed to tell the jury that it exists. The jury can decide on its own to disregard the law, and whatever the jury's verdict is, it stands, right? But you're not allowed to get a jury instruction. We had that case that was just, I think, 30 or 40 years ago. I think the Sixth Circuit came down with a decision reinforcing that you're not allowed a jury instruction advising the jury that they have the right to nullify a verdict. They can't do that. That's not allowed. You're not allowed to tell the jury that they can do it.
Yep.
But once the jury makes a decision, especially if it's an acquittal with our double jeopardy laws in the Constitution, that's that. We're done. So you can't do it.
As far as I understand, there are 4 states under state law that have an ensconced litigation, like an ensconced black letter law that gives the jury the right to nullify a law that says in their state statutes.
So once again, we've got a case 30 years ago in a circuit court case that said you can't, and then it didn't go to the Supreme Court. So here we are, we're bifurcated laws on this. So
bifurcated laws on that stuff. So my encouragement is when here in Arizona, for instance, right, if you get ensconced in a jury, right, you get impaneled is the word I was looking for.
There you go.
Part of your oath is that you agree to uphold the law.
Yeah.
You agree,
even if you don't like it,
to apply the law, even if you don't like it. And if you're the one that says there instead, now here's the thing, a lot of people don't understand this, like the jury room is sacred space. The jury cannot be recorded. They cannot be overseen. There's no bailiff looking over at what they're doing. The judge can't hear inside. They close those doors. That room is, I don't know that it's soundproofed, but it is, you know.
Pretty much. The one that I'm familiar with.
They're close. Yeah. And again, not, you know, so if somebody were to be standing right outside the door of the jury room, that would be improper and it would be impropriety. And so what they talk about in there, that's up to them.
With a few exceptions.
Right.
If somebody's trying to coerce others, or there are certain exceptions to that. But
threats,
for the most part,
coercion.
that's absolutely true. Yeah, right.
So if a juror comes out and says, they threatened to beat me if I didn't vote,
or pay me if I did vote.
Yeah, or pay me if I did vote. Now we got coercion, now we got a problem. Yeah. But other than that, again, what they debate and how they talk about things, now they might, that's why they send out a note to the judge that says, hey, we don't understand this thing. And then 9 times out of 10, the judge goes, read your jury instructions.
Yeah, reread them.
Reread your jury instructions. No, we need more than that. Nope, reread your jury instructions. I had a case not too long ago with a judge that for 5 days refused, the attorney that I was working for asked the judge to send them an instruction on a hung jury, that they didn't have to agree. 5 days. Yeah. And the judge said, no.
Yeah, judge's not going to do that. That's totally up to the judge. Yeah.
No, I'm not going to tell him about it. No. And then 5 days later, they beat each other up enough. Yeah. And I'm like, man, at some point you got to. Anyways, so as a guy who has stood before a jury, every time I've testified in front of a jury, I have looked at 14 really fine humans doing their best to understand a very complicated situation that they weren't involved in and that they shouldn't be expected to be an expert in. That's why I'm there, right?
That's right.
Expect to help educate them. And every time, looking very carefully. And some of those jurors, I remember the last case that I did, I had a juror who already had her mind completely made up and hated everything I had to say. I don't get to choose them.
If you begin the trial during voir dire as a juror or as a potential juror, and your goal is to get on that jury so that you can change the law or that you can change the outcome or you can have a politically motivated outcome, then you should disqualify yourself.
Right.
If you're going to ignore the facts of the case, if you know going in that I think all people that use guns should be acquitted, and I'm not even going to listen to the facts because I'm going to vote to acquit, then you should disqualify yourself.
Right.
And the jury instructions and the voir dire process is supposed to weed that out. So if you're being honest and following your oath and not committing perjury, then you would weed yourself out. You would reveal that prejudice. And if you're going to hide the prejudice and go in there with a motivated goal to affect the outcome of the trial to help your political motivations, right or wrong, I might agree with your political motivations. Right. Doesn't matter. That's not correct. That's not the law. It's unjust. It's immoral. We don't do that.
Well, and I could see a case, let's say, thinking on the other side, somebody's accused of a capital crime, and you are
anti-death penalty.
Yeah, you are philosophically opposed to the death penalty, and I can totally honor that philosophical position, that ethical position. Then the answer is, listen, that's in play here. I'm not.
Well, and there's no capital case where that's not a big part of voir dire. You know, if the defendant is found guilty and we proceed to the sentencing portion and we're seeking the death penalty, even if you personally don't agree with the death penalty, would you follow the law and vote for that if the facts show that you have to? And you have to answer yes, or you're not going to be on that jury.
Yeah. Or
and so if you answer yes, knowing that the answer is no, you just committed perjury, which is a crime, and also it's a moral violation of some code that you should have, I hope.
Yeah.
Yeah.
So I just want to be cautious with this, okay? And what I want is I just hear sometimes as a Second Amendment absolutist, and I am a Second Amendment absolutist. I believe you should be able to order an M240 Bravo Amazon Prime next day delivery. Okay, that's how pro Second Amendment I am. I worry about our rhetoric with this stuff sometimes. Okay, because what I worry about is we think we are, well, we know what the right thing to do is, but I think when you actually sit in a jury, those folks wear that weight very carefully. And they wear that weight, and I have a friend who was just involved in a murder trial. It didn't involve self-defense. It was really murder. Yeah. It was a really bad murder. And they convicted on that murder. But he talked to me afterwards about it and about how draining it was to wear the weight of this man's future and to really listen to all the evidence and to see the really gruesome crime scene photos and those things. And so I think that my hope is this. If I haven't been selected for a jury, since I moved to Arizona. I've been in voir dire one time in like 2007. So it's been forever since I've even been down to the courthouse as a juror. But recognizing that if I get chosen, I will do my job to the very best of my ability to serve the people of this community. Simple as that. That means I'm going to apply the law to the very best of my ability. And now I do think in some rare extreme cases, we might say, I can't enforce. There's common law here that says there's a higher common law, and that's where jury nullification comes from. Jury nullification is common law. Common law is old law. That's English law from as far back as the 12th century. I don't think jury nullification goes back that far, but that's how far common law goes.
I would be surprised, but yeah. Not if the Lord found out about it.
That's true. Not if the king found out.
Yeah, Lord or the king with small k, small l.
Yeah. And so, okay, I think you can make a case that says, well, maybe we have a higher law and an older law that we have to appeal to in that particular case, but be very careful with it. It should only be a last resort.
When we talk about jury nullification, this is sort of a painful admission for me to make, but I'm going to make it anyway. In Arizona, all attorneys are required to serve as arbitrators. So you're randomly selected, kind of like jury duty, and you're told that you're going to be working for probably 2 days for free to help out other lawyers who are getting paid. Which, for some people,
guys.
Especially for solo practitioners, it doesn't sit very well, right? I need that money to pay my payroll, but anyway, okay, fine. And but I've been a personal injury attorney as well as a criminal defense attorney for my whole career, and I have had clients get tossed around by insurance companies who are callous and unfeeling, and gigantic corporations that have literally billions, if not trillions of dollars in reserve, and they don't care about the little person at all. I mean, it's like the casino caring about that one guy playing blackjack. They simply don't care, right? And so every once in a while I get selected to be an arbitrator, and it's a personal injury case, and there's an insurance defendant on the other side, and I'm always like, fine, I'm going to get my revenge. I'm going to just nail that. I'm going to give that plaintiff $1 billion because man, it's time I turn this back around on that insurance company. And invariably, I end up voting in favor of the insurance company and voting against the plaintiff. I didn't feel the plaintiff had a strong case. And I guess that's a backwards compliment to myself that I can put aside that prejudice and actually do what the facts show me I should do and what the law tells me I should do. So I know it can be done because I've done it 5-6 times.
Yep.
And and you'd rather feel like you were vindicated and your prejudices were borne out and everything worked out the way. You can't do it. You just can't do it. You can't be. You got to be true to yourself. You got to be true to the system, true to the law, true to the honor code, and you got to vote the way the facts show you should vote. And
principle-based life, Yale.
Yeah, exactly.
That's what that is. That's living a values-based, principle-based life, and that value says no. The way, generally speaking, and generally as an almost universal rule, self-defense laws in America are good.
Yeah,
they're in every state in the union. They're really strong and really good. There's nothing here in the U.S. that I would really significantly change. Maybe about some firearms laws, but not about self-defense laws. And so going in there and saying, nope, I will be the person who stands between the state and the defendant and make sure that the state has proven their case that this person deserves to be punished for violating the law. That's my job, and I'll do my job. But that's as far as my job goes. And so be careful with that jury nullification stuff.
Yeah. Don't spout about it anyway.
Yeah.
Then
the second you start talking about it, it's over anyways.
Exactly. There's no such thing now. So
here's the other part of that. If you start talking, you sit in the jury room and you mention those words, guess what happens in the jury room when you mention the words, well, I think we should nullify here. Then somebody goes, Your Honor, we just talked about this thing. And the judge goes, and mistrial. Have a nice day. Guess what you just did? You just subjected the defendant to another trial.
You doubled the expenses for everybody. You doubled the time off from work for everybody. You just clogged up the court system again. Yeah.
Yeah, you screwed the pooch on that one. So don't do it.
You ain't solving anything. You're just making it worse. Yeah.
Tim, thanks for the knowledge.
As always, buddy, for what it's worth.